Michele Lucan is a Deputy Associate Attorney General at the Connecticut Attorney General's office and Chief of its Privacy Section. Michele joined the Attorney General's office in 2008 and first served in its Consumer Protection Division. In 2013, Michele was appointed to a multidisciplinary privacy task force that was created to focus the office's response to privacy concerns and data breaches. In early 2015, a dedicated privacy section was formed, and Michele was assigned to the section from its inception. And she has since worked exclusively on privacy and data security matters, and the perfect person for us to have this conversation with today from the Connecticut Attorney General's office. So, Michele, thank you for joining us today.
Thank you for having me.
So I want to take a step back a little bit, right? We have audience members who may be at varying levels of interest and understanding with regards to data privacy and matters surrounding data privacy. So let's lay the groundwork first by you describing really what does the Connecticut Attorney General's office do? So for the layman that wants to kind of understand, get up to speed, how do you explain it to a layman about what the Attorney General's office does? And also, I think the second part of that question is, how does the Attorney General's office work with the legislature?
Yes, great questions. And I'm happy to talk about our office and our work. So for those that don't know, the Attorney General's office handles all civil matters for the state of Connecticut. And then specifically for the privacy section, I head up a team of 6 attorneys and a legal investigator, and we are charged with investigating all matters impacting consumer data security and privacy. And so you mentioned that Connecticut has a standalone privacy section, and that is something that is very unique. So we were the first office in the country to create a dedicated privacy section. And because of that, Connecticut has really been in the lead for a lot of privacy enforcement in the past. So to give you a better sense of what types of matters our team works on, we do a lot of work on data breaches. So Connecticut law requires that companies that experience breaches involving Connecticut residents' personal information report those breaches to our office. We received over 1,900 breach notices last year, and our team reviews every single one. We have also either led or co-led investigations into some of the biggest data breaches that we've seen to date. And we have played a key role in negotiating data security settlements that really raise the bar for expectations concerning reasonable data security. And all of this has the result of ensuring that our data is kept more secure. We've also done a lot of work on the consumer privacy side of things. We've handled some of the earliest cases involving companies collecting data without our knowledge or consent. And that all brings us to today. And Connecticut was one of the first states to enact a comprehensive consumer data privacy law, and that has kept our team very busy. We have exclusive enforcement authority under the law, and we have now at this point issued 2 separate enforcement reports about our work under the law, and those are available online. I hope that folks listening will take the opportunity to read those reports because it's some really interesting work all aimed at upholding Connecticut residents' privacy. Now I can talk a little bit about our legislative work. So we work very closely with the legislature. We review any privacy-related bills at the state level and at the federal level, and we make suggestions to enhance the privacy protections in those bills. We also regularly advocate for changes to existing laws. That's something we care about a whole lot. Because we're often in the lead on privacy enforcement, our laws are often looked to as guidelines for other states doing privacy enforcement. So we really want to make sure that we get this right, and we play a very active role in reviewing legislation.
Great. So you mentioned Connecticut's work in the consumer privacy space, and the first law passed. Connecticut's first law passed in 2022, right? The consumer privacy law passed in 2022, but we've seen updates since then, and in particular, in the most recent update, which I'd ask you to talk about a little bit, which was signed by your governor on June 25th. So can you please speak a little bit about, I guess let's give a very, high level overview of what the existing law is, and then some of the changes with regards to this update.
Yes, I can. So, yes, you're right. The Connecticut's privacy law passed in 2022. It took effect in July 2023. It was amended before it even took effect to add protections for kids' data and health data. And now it was just recently amended again to strengthen the privacy protections in the law. So this is the privacy space is not static. Technology is not static. These laws are constantly evolving. But for Connecticut's law, it was updated for some very good reasons. So I will take a quick step back and talk a little bit about what the law does. So this is a really important law in Connecticut. It gives Connecticut residents more control over their personal data. This includes the right to ask that our information be deleted, the right to access information that companies are holding on us, the right to opt out of the processing of our data for sale or targeted advertising. It also solidifies privacy obligations on behalf of those businesses covered under the law. So things like requiring companies to minimize the data that they collect, to only use the data that they collect for the purposes that they have disclosed to consumers, to implement reasonable data security measures, to do data protection assessments, which basically means be careful about the processing of personal data and to really think hard in advance about the risks related to those processing activities. So it's a really important law, it's multifaceted, but in our early enforcement work, we became of certain weaknesses in the law that we felt very strongly had to be addressed. And then also, because we were one of the first states to pass a comprehensive consumer data privacy law, other states have done some really good work to raise the bar for those privacy protections since our law's passage. So the point of our amendments were twofold: address those weaknesses and then also pull in that stronger language that other states had added. So where does that leave us? There's some really interesting components of these amendments, which will take effect on July 1st, 2026. For example, there is Connecticut's law requires opt-in consent for the processing of sensitive data. And these amendments expand the categories of sensitive data that are covered under the law to include some really sensitive categories of data, including neural data. We've also broadened the applicability standard under the law so that now the law applies to processing of 35,000 Connecticut residents' data. It used to be 100,000, which was simply too high for a small state like Connecticut. The law also now applies to companies that are processing any sensitive data or selling any information. So that was a change that I think makes Connecticut's applicability standard the most broad in comparison to other states. And then there's also some key protections that were enhanced for minors' data, something that could not be more important right now. So that's a snapshot of the changes, but really the idea is these laws are going to continue to evolve as we become aware of new technologies and new privacy harms. And for Connecticut, we will keep paying attention to what other states do to make sure that Connecticut residents' privacy rights are just as strong as they are in any other state.
So I want to go back and touch on a couple of things that you mentioned. First is the amendments came about because you all were looking at what some of the other states were doing. And I think that there may be this fallacy amongst both consumers as well as industry that either state AGs don't talk to each other, are in competition with each other. Can you talk a little bit about how attorney generals across the states work together or don't?
Yes. So we work together a whole lot. At the state level, privacy regulators are a close-knit group. We've always had a lot of coordination in the privacy space. I mentioned our work on data breaches and some of the earlier consumer privacy cases. These were all multi-state coalitions. So what I mean by that are states banding together to work on investigations. We draw upon other states' resources. Some states have developed real expertise in certain areas. So this is something that benefits everyone. So there is a whole lot of coordination in this space. That is something that is sure to continue going forward. And we also talk very frequently about state privacy bills too. So this has been a coordinated effort on behalf of the states to make sure these laws are consistent. There's a lot of talk right now about the patchwork of state privacy laws, and I think that is something that has not really played out. There's a lot of consistency in these comprehensive consumer data privacy laws, some of which is a direct result of our conversations with our colleagues and our own efforts to drive towards consistency. And what this allows for is more coordination. So we talk a whole lot. We work together really well. It's a good group of people that we really enjoy working with and who all care about doing very meaningful work in this space.
Mm-hmm. I mean, the effort, I think, to create a level playing field that right now doesn't exist because we don't have an omnibus federal privacy bill. It it does fall at the feet of the states to help create that, right, for businesses, as well as for consumers, understanding what your rights are. So I appreciate, and I know we all do appreciate the efforts of the states. You also mentioned children's privacy, which is always a hot topic. It's always a hot topic at BBB National Programs. We oversee the first FTC approved COPPA Safe Harbor program and are continuing our work in that space. We have our teenage privacy program. I'd be interested if you could just dive in a little bit on what the priorities are for Connecticut with regards to children's privacy. And I think one of the interesting things is that there are some state laws where sensitive data encompasses children and other states do not encompass children when they talk about sensitive. I know, and Connecticut defines them separately. But what are the pressing concerns for Connecticut with regards to children's privacy?
The great question. Our office cares very much about protecting kids online, keeping kids safe online. And we've spent a lot of time talking about these issues in our office. So one of the first things we did was take a hard look at the language in the law related to minors protections. And this was an area that we advocated for very strongly to make sure those protections would be enhanced. So I can give an example of that. So under the law, before it was amended, a controller needed to obtain a minor's consent to sell personal data, engage in targeted advertising, and engage in profiling. So this raised a lot of questions for us. Is that type of consent structure appropriate when you're talking about minors? And especially knowing just how valuable children's data is to these companies. So, we had a lot of careful conversations about that. So the law previously had a consent standard, but the law was updated to remove that consent standard. So it now states that a controller cannot sell personal data or engage in targeted advertising directed to minors, regardless of whether it obtains consent, something that we thought was very important. Also, under the pre-amended law, a controller could obtain a minor's consent to use a system design feature that was aimed at keeping kids addicted online. So the language was to significantly increase, sustain, or extend any minor's use of such online service, product, or feature. We advocated for amending the law to remove the consent structure in that area as well. So now it's an outright prohibition, something that's really important as well.
So have you heard back from businesses, from industry about we know that they're going to argue that this is a challenging thing for them, right? That's not your issue, and that's their issue. But have you heard from them, received questions from them about how they're supposed to do this? What it should look like with regards to how they're treating children's sensitive data? I mean, the outright ban is one thing, and that is what it is, and they have to figure out a way to operationalize that. But with regards to just how to navigate the children's space with regards to Connecticut's law, have you received any questions from industry?
Yes, we get reach outs like that all the time. And this is something we're always happy to talk to companies about, to listen to these questions, try to understand what particular challenges are involved with respect to compliance. We can't provide legal advice, so this is all with that caveat. So we will listen. We care about these challenges. And even though we can't provide individual legal advice, this is something that we will take into account when reviewing companies' compliance with the law, and is also something that we could at some point issue further information on, either on our websites, our privacy sections FAQ page, or through an enforcement report. I mentioned that we had issued 2 of those already. So companies have regularly come forward about areas like this. But from our standpoint, this law is important. These protections are important, and companies need to comply with the law.
Right, absolutely. This is a consumer protection issue, right? This is not about protecting businesses. This is about protecting consumers. So to that end, how has privacy changed for the consumers that live in Connecticut from 2 years ago, right, when the law was first enacted in 2022 until now? Do you believe that consumers understand their rights? Do you believe that they're engaged? What kind of feedback are you receiving for consumers? And again, how has it changed for them in the course of the last, 2.5, 3 years?
This law has been a game changer for Connecticut residents and our privacy. So first, we have these really important rights over our personal data, more control over our personal data. And while we would have always taken the position that these companies had obligations to protect privacy, now they are there written into the law. I think Connecticut residents have responded really well to the new law. Connecticut residents care about their privacy. They are attempting to exercise their data rights. Our team directly handles all consumer complaints that we receive under the new privacy law. And we have received very detailed complaints from Connecticut residents about any failures on behalf of companies to comply with the law. So it is pretty impressive to us, the level of detail that we get in these complaints. And what is overwhelmingly clear to our attorneys is that Connecticut residents care about these rights. They want to exercise them. They care about their privacy, and they want to take control over their data.
Great. And I'm sure that your website has tons of resources, which we will link to in our resource section as well. We will link to your website where you provide all of these resources. I want to pivot a little bit to, you did mention enforcement reports. In the end of April, you came out with a new enforcement report, which provided an update on enforcement priorities. Can you go into a little bit of detail there?
Yes. So when Connecticut's privacy law passed, there was a mandatory requirement that we issue a report on our early enforcement efforts. So this covered the first 6 months of enforcement, and we issued an initial report with a lot more detail than was required of us under the law, because we care so much about being transparent. I think it benefits everyone if we are transparent about our compliance expectations, and we didn't shy away from saying, here are the areas that we're working on, and here's what we expect in terms of compliance. So this second report that we recently issued was not mandatory at all. This was something that was completely voluntary on behalf of our office to keep up with that tradition about being transparent about our expectations. And so what we did in that report is talk about some areas that we are paying particular attention to. So I can give you a quick overview of some of the areas that we highlighted in the report, but it's very detailed. And like I said, I hope folks will read it and give us any feedback. But one of the areas that we are looking at is transparency. We're being transparent. We care about companies being transparent. And there are some really important provisions in the law requiring companies to be clear about the data that they collect from Connecticut residents, what rights Connecticut residents have, and how Connecticut residents can effectuate those rights. So we have been reviewing public-facing privacy notices and following up with companies whose notices are deficient. This has been a broad effort from our office. We've now issued 4 separate sweeps, we're calling them sweeps, related to deficient privacy notices. Even though this law has been in place for 2 years, we're continuing to find notices with glaring deficiencies. And so that's something we're going to keep paying attention to. Another area that we've been looking closely at are opt-out rates. So this is something we highlighted in our enforcement report too. We have been reviewing not just privacy notices, but also problematic cookie banners. And so we have all seen these, you're visiting a website and a cookie banner appears, and it's very easy to hit accept to the processing of your data for sale or targeted advertising. And it's extremely difficult to reject that or opt out of that. And so that's something that our team has been doing a lot of work on. We've issued sweeps related to those types of problematic cookie banners. And the takeaway is that companies that are using cookie banners need to make sure there are symmetrical options so that it's just as easy to opt out as it is to opt in. We are paying attention to sensitive data collection. So I mentioned for Connecticut, it's an opt-in structure for the collection of sensitive data, and companies need to get Connecticut residents' affirmative consent under the law to process that information. And we have been looking at consent mechanisms under the law, and we have been pursuing companies whose consent mechanisms are non-compliant. And then last but not least, something that we flagged in the law is that our universal opt-out provisions came online on January 1st of this year. And I know this is something that we will talk more about later, but we signaled that because those universal opt-out provisions are so important, that we will be very focused on those provisions going forward. We had done an extensive outreach effort on those provisions, and the message that we provided was clear, is that companies need to honor universal opt-out signals sent by Connecticut residents.
First of all, I applaud the actual opt-in model. I think that opting out is very easy. I think opt-in actually requires people to do a little bit more thinking about their choices, right? And possibly reading maybe a paragraph here, a paragraph there in an existing privacy policy, but opting in seems like a much more affirmative way for someone to say I actually made some choices, and I'm aware of the choices that I made. And the cookie banners that drive me crazy are the ones that just say accept all, and that's the only option. So for those companies, those businesses that are listening, that's not a choice when you just say accept all. So I do want to just touch on very quickly, we did talk about how Connecticut AG's office works with the other AG offices, but what are obligations that you think are unique to Connecticut that we're not seeing in the 20 other states? And what is it that businesses need to be doing when, they're forecasting for what they want to do 6 months down the line, a year down the line? What are their obligations today? What should they be thinking about, as their future casting for their online website services, whatever it is, their businesses, whatever it is, what's unique to Connecticut, but overall, what should they be paying attention to? And I'll start with, I think we can all agree that data minimization is top of mind for everybody. If this is not back in, the early 2000s when it was collect all the data that you want today, your privacy policy can use language like we may do this, we may do that. Those days are over. And you can't just collect data and hold on to it indefinitely for any reason because, 6 months from now, your marketing team may decide, oh, wait, we want to use it for that. So those days are over, but unfortunately, we still see those practices.
Yep. Well, I could not agree more. Data minimization is everything. This is something we've said for a very long time, even before this law took effect. I can't tell you how many data breaches we've reviewed where we ask, why did you even have that data? And we don't get a good response. Or why did you keep that data for so long? And there's no response to that too. So yes, data minimization is something that is top of mind. That is something that we included in our legislative recommendations too, is encouraging the Connecticut legislature to look at our law and continue enhancing the data minimization provisions in the law. So our law has a requirement for data minimization, something that's really important, but other states have made changes to raise the bar for data minimization. And this is something that we will continue advocating for in Connecticut. And I hope we get there. So you also asked about what are the unique aspects of Connecticut's law. And I think really it's a difficult question to answer because, like I said, these laws are ultimately very similar. They are built off of the same foundation. They have the same bones. And so for Connecticut, a lot of these changes were really a drive towards consistency with other state laws. I think the areas where Connecticut's law is especially strong have to do with consumer health data and kids data. So those are areas to look at Connecticut's law in particular and pay attention to those nuances. But on the whole, these laws, despite the fact that they are passed in different states, really set up a framework that is consistent. And for companies looking to comply, those companies can leverage compliance efforts that they're making for some of these earlier states, for states that are coming online after.
Right. I mean, if Connecticut is holding the bar higher than other states, then for those businesses and companies that are listening today, hold the bar where Connecticut is holding the bar, and then you will meet the test in other states. Don't shoot for the bottom of the pile, shoot for the top of the pile. So, Michele, I want to ask you to look into your crystal ball, and can you share with us kind of about, we're halfway through the year. What does the rest of the year look like for Connecticut? What are some priorities for you? We haven't even said the two most, famous popular letters that everyone's talking about today, AI. So is that on I imagine it's on the radar for Connecticut, but where are you looking to take the lead? Where are you looking to pivot in the remainder of the year?
I love this question. I wish I really did have a crystal ball, but let me try. I think what we will see this year is increased enforcement. So now some of these laws have been in effect for years. And so, like I said, there's no excuse for noncompliance at this point. For Connecticut in particular, when our law passed, it contained a cure period, which basically required our office to give companies notices of potential violations as we became aware of them. And that was something we did. A lot of these sweeps that I mentioned before involved cure notices where we gave companies an opportunity to comply. And we really did see a lot of cooperative efforts towards compliance. That cure period has now phased out, which I think makes sense because now we are years down the line. So this is something that has already shifted our enforcement approach. And I think will in other states, as you see these cure provisions phase out, or states pass laws without those cure provisions at all, now that companies have been on notice. I think you'll also see continued and enhanced coordination amongst privacy enforcers. So we spoke about this up front. I talked about the good level of coordination we've always had in the privacy space. We also recently announced that we joined a bipartisan consortium of privacy regulators. So that's something that I think will be a great forum for us to continue discussing these privacy issues, make sure we're aligned and that we're working together to the benefit of our state residents. So I think that's also something you will see is so not just enhanced enforcement, but also continued cooperation and collaboration. And then in terms of priorities, some predictions there, I think, so in our enforcement reports, we called out some industries that we are paying attention to, which we will continue paying attention to, areas like data brokers and connected vehicles and companies handling kids' data. So I think that is something that will stay on our radar. And then you mentioned AI, and that is, I think, top of mind for everyone right now. There are provisions in these laws that apply in the AI space, including the opt-out for profiling. And there are also something that I think gets lost is that even though these laws are newer, these comprehensive consumer data privacy laws, we have an array of existing state laws that apply to the privacy space, including laws prohibiting unfair and deceptive trade practices, prohibiting anti-competitive harm, prohibiting discrimination. So we already have a lot of tools that we can look to in this space, and hopefully that authority will be preserved. And, because now is the time. Now is the time to do good work in this space. And it's something that I think across the board, state AGs are paying attention to.
Yeah, absolutely. I think you pointing to those laws that are agnostic to technology, and no matter what we're doing, whether it's AI or whatever is going to come after AI, those laws will continue to support while we continue to make advances in the specific privacy and technology space. So, thank you so much for joining us today. I really appreciate you giving us kind of the top level overview of Connecticut's data privacy law, what makes it unique, and how you're supporting your Connecticut residents and protecting them. And that's what these laws are all about.